Hello friends, I welcome you all to this session on law of evidence. In this session, we will be discussing one part of section 32 and section 33. Remember friends, section 32 has got in total 8 parts, and here we will be only discussing about the first part, that is the dying declaration, and then we will be discussing section 33. The rest part of section 32 will be having a separate video on that. So before starting, let us have a brief overview of what all we are going to discuss in this session. First, we will see that what is dying declaration, what is its evidentiary value. Then we will also be discussing the difference between English law and Indian law as far as the dying declaration is concerned. And then we will see section 33. So let's start with section 32. So section 32 and section 33, they deals with statements that are made by a person who can no longer be called as witnesses. Suppose there is a person A, he has given a statement, but in the later stage or at the later stage he cannot be called in the court because of some reason, or he cannot come in the court of law because of some reason. Then what is the relevancy of his statement, and to what extent his statements are relevant? That is what is given under section 32 and section 33. Now, as far as section 32 is concerned, it lays down 4 conditions when a person who has given a statement but he cannot be called in the court of law. Now, what are those conditions? So, suppose a person A, he has made a statement and now he is dead. So, certainly, if he is dead, he cannot be called back. Someone cannot be sent to the heaven or hell wherever he is, and would be asked to come before the court. Second is that if he cannot be found, suppose that person has gone missing for a long period of time, and after all due diligence he cannot be found. Another is that if he is incapable of giving evidence, suppose he has gone in a ICU in a coma stage. Now then he is incapable of giving evidence. Then whose attendance cannot be procured without unreasonable delay or expenses. So these are the 4 conditions when under section 32 the statement made by a person becomes relevant. I will just repeat: if person who has given the statement is dead, or he cannot be found, or he is incapable of giving evidence, or he cannot be called in the court of law without unreasonable delay or expense. Now, the principle behind this section is that the court, if a person is not able to appear before court because of some valid reason, then the court can take the previous statement and consider it in order to find out the truth. So this section 32, it is a exception to the rule of exclusion of hearsay evidence. As we have discussed earlier, that there are 3 golden principles, and in it one of the principle is that hearsay evidence will not be taken. Now section 32 is an exception to this rule of exclusion of hearsay evidence. So the principle behind this section is that any person who has first-hand information of a fact not able to appear before the court due to any reason stated in this section, then his knowledge should be transmitted to court through some other person. That is, because if a person has given a statement and he himself cannot come to the court because of those 4 reasons which we have stated earlier, then yet his statement can be taken into consideration by the court even if it comes through some other means. Now, in it, the first part deals with dying declaration. Now, what is dying declaration? Dying declaration means any statement made up by a person who has died. So, if a person, suppose there is a person C, he has given a statement, and after giving the statement, he is dead now. And this statement relates to cause of his death or circumstances which led to his death. Then this statement is called the dying declaration. So dying declaration, what is dying declaration? Dying declaration is a statement that is made by a person who is dead, and it relates to cause of his death or circumstances of his death. Now, according to section 32 clause 1, in order that dying declaration be relevant, there are certain conditions which should be fulfilled. Now, what are those conditions? Actually, there are 6 conditions which should be fulfilled. First of all, it should be a statement. Now, it may be in oral form or it may be a written form. Whatsoever it is, both oral as well as written form are acceptable. Second, this statement should be regarding the cause of the person who has died. So, cause of the death or any circumstances of the transaction which resulted in death, or this statement should be regarding the cause of his death or any circumstances which led to his death. Then the person who has made this statement, he should have had died. So this is the third thing which is important: death of the person who made the statement. So the person, suppose C, if C has made the statement, then death of the C has must have taken place. Then fourth is expectancy of death while making a statement is not necessary. So if suppose he made a statement without knowing that he is going to die, yet that statement will be valuable, or yet that statement will be relevant as far as dying declaration is concerned. Then in the proceeding, in which type of proceeding such type of a statement will be relevant? So the in the proceeding where the cause of the death of the disease is in question. So where the proceeding is regarding the cause of his death, in that case that statement will be relevant. And then another thing is that it is relevant both in civil as well as in criminal proceeding as far as Indian law is concerned. So that is, these are the essential conditions that must be fulfilled in order to fulfill the for the statement to be relevant under section 32 clause 1 as dying declaration. Now, what is the principle behind it? What are the main principle behind it? So, friends, there are two important principles behind it, and that is why this, though it is a hearsay evidence, that is, the person who has said it is not present in the court and he is not saying in the court. Rather, it is coming through some third person. That is, it is a hearsay evidence. And as per the golden rule, hearsay evidence must not be admitted. Yet, this type of a statement are admitted. Why? Because of basically two important principles behind it. Now, one principle is that of necessity, and another is that of extremity. So, one is necessity, another is extremity. Now, what is necessity? Necessity is that the person who has died, it is he who is the best person or best source to reveal his cause of death. No one would know as to what has happened in a closed room where two persons were there and one of them has died. So, the person who has died is the best source to reveal his cause of death. and therefore it is out of necessity that his declaration is admissible. Another is extremity. Extremity is that there is a principle behind it, and please remember it. This has been asked many a times. Nemo moritus presumptuor mentiri. That is, no person will die with a lie on his lips. No person will die with a lie on his lips. That is, it is believed that a person who is on the deathbed will not be inclined to say truth because he is in a feeling that he is leaving the world. In Ukaram versus state of Rajasthan, the Supreme Court held that the sense of impending death produces in man's mind the same feeling as that of virtuous man under the oath, and chance of falsehood are totally nullified. So the presumption behind it is that person who is on the deathbed, he will not be inclined to tell lie. He will be in the same condition as a person under oath who is speaking before the court. So this is the principle behind this relevancy of dying declaration, or why though the statement is a hearsay evidence, yet it is admissible. Now, one very important question that has been asked time and again is that difference between Indian law and English law regarding dying declaration. So basically there are two differences between Indian law and English law as far as dying declaration is concerned. The first is that under English law, expectancy of death is must. That is, the person who has made the dying declaration must be under the expectancy of death. He must believe that he is going to die. While under Indian law, it is not necessary. So even if that person is not under an expectancy of death, he makes a statement and later on he dies, yet that statement will be relevant under Indian law. But that same statement will not be relevant under English law. There is very important case law on it, that is Pakala Narayan Swamy versus Emperor. In this case, this person, he made a statement to his wife that he is going to collect money from a person. Later on, after some day, after a few days, his dead body was found. Now, this statement he made to his wife was not under expectancy of death, yet as it revealed the circumstances of transaction which resulted in his death, therefore it was relevant under Indian law as a part of dying declaration. Same would not have been relevant under English law, because the time when he made that statement, he was not under the expectancy of death. Then another is that under English law, it is valid only when the charge is that of murder or manslaughter. That is, it is only relevant in criminal cases, while in Indian law, it is relevant in both criminal as well as civil cases. So these are the two important differences between Indian law and English law as far as dying declaration is concerned. Okay, now let us now see what is the evidentiary value of dying declaration. So as far as evidentiary value of dying declaration is concerned, one has to keep in remember that there is no bar, that is, a dying declaration can be sole basis of conviction. Mind you, my friends, the word I use can, not shall. If the court is fully convinced about the truthfulness of the dying declaration, if the court is fully convinced about the voluntary nature of dying declaration, then dying declaration can form the sole basis of conviction, even though if it is not corroborated by independent evidence. That is, no corroboration would then be required. Provided court is satisfied about its truth, court is satisfied about its voluntary nature. This was stated in Kushal Rao versus State of Bombay. So in Kushal Rao versus State of Bombay, the Supreme Court stated that dying declaration, if the court is convinced about its truthfulness or voluntary nature, can form the sole basis of conviction. However, if the there is doubt regarding its truthfulness, if there is doubt regarding its voluntary nature, then corroboration may be required. So, in Sampat v. Kale versus State of Maharashtra, the Supreme Court was of the view that if the court is not able to fully accept the truthfulness of dying declaration, corroborative evidence may be required. So, Supreme Court held that though conviction can solely be based on dying declaration, corroborative evidence may be required when there is doubt as to whether the victim was in a fit state of mind to make the statement. So, the in Kushal Rao versus State of Bombay, the Supreme Court said that it can form the sole basis of corroboration if it is true and voluntary in nature. In Sampat v. Kale versus State of Maharashtra, Supreme Court held that if there is any doubt regarding the dying declaration, corroborative evidence may be sought. Now, why is this? What doubt, or why is it not safe to fully rely on a dying declaration? Now, there are three main reasons because of which it will not be very prudent to rely totally on dying declaration. One of it is that it is not made on oath. There is only presumption that a person who is on deathbed will not be telling a lie, so that it will not be on oath, and it is not subject to cross examination. So the person has given the statement, but physically he has not taken an oath. There is only a presumption, and then there is no cross examination which has taken place. Another is that it is another reason is that of extremity. That is, the person who is in a dying state, or who is going to die, or who knows he is going to die, he may not be physically and mentally in a fit state to give a statement. That is, the maker may be physically or mentally in a state of confusion. And third is that it, if that person who is dying is very cunning, then he may take advantage, or he may take its advantage as last opportunity for implicating all his enemies. That this is his last opportunity where he may take revenge from all the enemies he has. So these are the main three reasons why it is not safe to rely totally on dying declaration. One, it is not made on oath and is not subject to cross examination. Second, it is made in extremity. The person who is making it may not be physically and mentally in a uh, state, in a fit state. And third is that the person who is dying may take advantage of it as last opportunity for implicating all his enemies. Then, is statement made by signs are also uh, relevant? Then, suppose there is no statement. What the person who is going to die, he has just made some hand signs. Then, in Queen Empress versus Abdullah, the court held that dying declaration made by signs and nod is also relevant. So if the person has not spoken anything, he has not given in written anything, but he has just nodded his head, he has just made some signs by hand, yet that will be relevant as far as dying declaration is concerned. Then what would happen if suppose A has made a statement when he was expecting that he is going to die regarding his cause or circumstances of his death, and then because of very good medical support he survives, he does not die. So in that case, his statements can be used for corroboration under Section 157 of Indian Evidence Act or for contradiction under Section 145 of Indian Evidence Act. But that will not be used as a dying declaration under Section 32 Clause 1. This was held in Maksudan versus State of UP case. So, as far as dying declaration is concerned, these are important points you should remember. Now, another section where the same concept is there, that is statement of a person who can no longer be called in the court to verify his statement. Now, suppose there is a proceeding which is going on, and in this proceeding there is a person B, he has made certain statement, but later on in later proceeding, in subsequent proceeding, he is not able to come because of some reason. Then is his this statement which he has made in previous proceeding, will it be relevant in the subsequent proceedings or not? Now this has been answered under Section 33 of Indian Evidence Act. I will once again say, suppose there is a person B and he has appeared before court, and in this proceeding he made certain statements before the court. Now, once he has made this statement before court, later on in subsequent proceeding he is not able to come because of certain reasons. Then is in the subsequent proceeding the statement he had made in the previous proceedings, are they relevant? Then Section 33 says they are relevant provided certain conditions are fulfilled. What are those conditions? Those conditions are that, first of all, he should not be able to come because of certain fixed reasons. One, he is not able to because he is dead. He has already died and therefore he cannot come in subsequent proceeding, or he cannot be found as such, that is has gone missing. Then he is incapable of giving evidence. Suppose he is so sick, he is because he has gone in coma and therefore he is incapable of giving the evidence, or he is kept out of the way by adverse party. Suppose the adverse party has kidnapped him or has done anything to him because of which he is not able to attend the subsequent proceedings, or his presence cannot be obtained without an amount of delay or expense which the court considers unreasonable. So, if these four conditions are fulfilled, so I told you that the statement will be relevant provided certain conditions are fulfilled. There are two set of such conditions. One set is his reason of absence. His reason of absence should not be that willfully though he is able to come and yet he is not ready to come, or yet he is not coming. There should be some compelling reason because of which he is not able to come in the subsequent proceeding. And what are those compelling reasons? That he is dead, or he cannot be found, or he is incapable of giving evidence, or he is kept out of way by the adverse party, or his presence cannot be obtained without an amount of delay or expense which the court considers unreasonable. So this is one set of reason which should be one set of conditions which should be fulfilled for the statement to be relevant. Another condition that should be fulfilled is that the subsequent proceeding must be between same parties or their representative in interest. So if this proceeding was between A and C, then the subsequent proceeding should also be between A and C or their representative in interest. So this is one of the second set of conditions. Another is that the adverse party in first proceeding has right and opportunity to cross-examine. Suppose B has come in favor of A. Then in this previous proceeding, C which is the adverse party, must have the right and opportunity to cross examine B regarding his statement. So, this is another condition which must be fulfilled. Then, the question in issue are substantially the same in the first and the second proceeding. So the question which are issued in the previous or in this proceeding must be substantially the same, must be same or substantially the same in the subsequent proceeding. So if these two set of conditions are satisfied, then the statement given by this B in previous proceeding will be relevant in the subsequent proceedings also. So, where a person appears before a court and testimony is recorded, but at a later stage of proceeding, he is not available as a witness, then under section 33 applies, and his testimony previously recorded can be used for purpose of proving the truth of fact which he states. But for that, following conditions must be satisfied. That is, witness is no longer available as he is dead or cannot be found, is incapable of giving evidence, or is kept out of way by adverse party, or his presence cannot be obtained without an amount of delay or expense which the court considers unreasonable. And second set of conditions which must be fulfilled is that the proceeding must be between same parties or their representative in interest. The adverse party in the first proceeding has the right and opportunity to cross examine. The question in issue are substantially the same in the first and in the second proceedings. So that is what is section 32 clause 1 and section 33. So I will have a brief recap of what all we studied. Section 32 and section 33 are makes relevant statements by person who cannot be called as witness. Both of these are exception to the rule of exclusion of hearsay evidence. And dying declaration, section 32 clause 1 deals with it. The essentials of it is that it must be a statement, it must relate to cause of death or any circumstances of transaction which resulted in the death. The person who has made it must have died. Expectancy of death is not necessary. Cause of the death of the disease must be in question, and it is relevant in civil as well as in criminal case. The principle behind it is that the necessity, that is the person who has died was the best source to reveal his cause of death, and extremity, that is nemo moritus presumptio mentri, that is no person will die with lie on his lips. The difference between Indian law and English law is that under Indian law, expectancy of death is not necessary, while in English law, expectancy of death is necessary. Then in the Indian law, it is applicable both in civil as well as in criminal case, while under English law, it is applicable only when in criminal offenses, when the accused is charged with that of murder or manslaughter. Then, as far as its evidentiary value is concerned, it can form the sole basis of conviction if the court is satisfied regarding its truthfulness and voluntariness. However, if there is any doubt, then corroborative evidence must be sought. Why there it is not safe to rely fully on dying declaration? Because it is not made on oath, nor it is subject to cross examination. Then it may be that the person who is making it may not be in a physically and or mentally fit state to make the statement. Then the person dying may take it as an advantage or last opportunity for implicating or taking revenge from all his enemies. Then the statement made by signs are also relevant, as has been upheld in Queen Empress versus Abdullah case. And then if the person who has made the dying declaration and he survives, then his statement can be used under section 157 for corroboration and section 145 for contradiction. Then as far as section 33 is concerned, Section 33 deals with relevancy of certain evidence which is given in previous proceeding with in subsequent proceedings. But for the statement given by a person in previous proceeding to be relevant in the subsequent proceedings, certain conditions must be fulfilled. What are those two set of conditions? One is that the person must be would have had died or cannot be found, or he is incapable of giving evidence, or he is kept out of way by the adverse party, or his presence cannot be obtained without an amount of delay or expense. The second set of conditions which must be fulfilled is that the uh, proceedings must be between the same parties or their representative in interest. The adverse party would have the uh, right and opportunity in the previous proceeding to cross examine the witness. And third is that the question in issue must be same or substantially same in both previous as well as subsequent proceedings. That's all for today. Thank you, friends.